Hello, everyone. I am Carmel Shachar, the Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. I am here to welcome you to our event, Enforcing Constitutional Commitments to Health and Social Equality in Kenya. I know that I fall into the very classic American trap of focusing a lot on what's happening within the borders of the United States, especially this year with the pandemic. I think it's really easy to turn inward and focus on your community. However, health and health rights do not end at the borders of my town or my state, or certainly not the United States. And that's why I always look forward to the events held by the Global Health Rights Project. Before I hand it over to our Senior Fellow in Global Health Rights, Alicia Eli Yamin, to fully introduce the event, just a few housekeeping things, the equivalent of telling you where the restroom might be if we were able to host you on campus here at Harvard Law School. We welcome questions. There are two ways for you to submit your questions. The first is to use the Zoom Q&A feature. If you go down towards the bottom of your Zoom screen, there should be a Q&A box. If you submit those questions, they will go to Alicia Yamin, and she will be monitoring them and feed them into the conversation. You can also join us on Twitter using the hashtag #HealthJusticeKenya. Again, that's hashtag #HealthJusticeKenya. You're welcome to just join the conversation, but if you submit a question there, Petrie-Flom staff will be monitoring it, and we will pull that question and put it into the Zoom feed. The ways that you cannot submit a question, please do not use the Zoom little blue hand feature. It's very cute, but we will not be monitoring it. As well as please do not use the chat. We're reserving the Zoom Q&A and Twitter for the two venues for questions. With that, I would like to hand it over to Alicia Eli Yamin, Senior Fellow in Global Health and Rights, the Petrie-Flom Center, as well as Senior Advisor on Human Rights at Partners in Health. Alicia, thank you for setting the stage for us.
Thanks, Carmel. And it's really a great pleasure for me today that we can host Mumbi Ngugi, who is a judge of the High Court of Kenya. I lived in East Africa for a number of years, and Kenya is a very easy country to fall in love with, and it's also a country that will break your heart when you see some of the pain and injustices that are going on. And I have long, from the time I lived there, I have long admired Judge Ngugi and her jurisprudence. And I think at a time when this country is facing extraordinary polarization and questions about what the courts can do here to promote greater egalitarianism, we couldn't have better timing to bring this event to Harvard Law School and to have a conversation with a real champion of human rights who now sits on the bench. Judge Ngugi is a long-time advocate of human rights in Kenya. She's been involved in advocacy work for rights of women and children and housing rights of the urban poor, and has also been a prominent activist for the rights of persons with albinism in Kenya. Prior to being appointed to the bench, she was, for 6 years, the lead researcher and compiler of the Kenyan Human Rights Commission's Human Rights Report. She holds a Bachelor of Laws from the University of Nairobi, an LLM, a Master of Laws in Commercial and Corporate Law from the London School of Economics. And she was the recipient of the 2013 International Commission of Jurists Kenya Jurist of the Year Award, the Brand Kenya Ambassador Award in 2013, the Law Society of Kenya Distinguished Service Award in 2017, the CB Madan Award 2018, and the Transparency International Judicial Integrity Award in 2019. We're really tremendously honored to welcome you here to Harvard Law School, and I only wish it were in person, Justice Ngugi.
Thank you very much.
So I'll start by just asking you, recognizing that we are all in the middle of COVID, even though on Zoom, how things are in Kenya and whether people are able to access justice during this pandemic.
Thank you, Alicia. As you know, I think this pandemic has really made everything around the world virtually grind to a halt. But matters justice, I think, cannot really wait. And we have been doing our best in very difficult circumstances to make sure that we are still able to proceed with matters justice. From the start of the pandemic, I think we've got the first few cases in Kenya in March of this year. We got guidelines from the Ministry of Health on what to do in the courtrooms in order to avoid widespread transmission of the virus. So the social distancing requirements, the wearing of masks, making sure that we do not have crowded places, we do not use our courtrooms where the ventilation may not be too good, were the areas in which we put a lot of emphasis in the last few months. We have also tried to use internet connectivity to make sure that people have access to justice. So we've been hearing cases where we are able to, through either Zoom or Microsoft Teams. Of course, there have been challenges with that because sometimes there are challenges of internet connectivity, so that some courts, especially in the rural areas, may not have sufficient internet connection to facilitate proper hearing of cases through the internet. But there've also been quite some innovation, because at times you will find some judicial officers are holding their sessions in car parks outdoors to ensure that we do get the cases moving, but that you also limit the number of people who are exposed to the virus. It hasn't been easy. We've had cases spreading sometimes in the registries and sometimes within the court precincts. But when that happens, we have closed them down for a while to make sure that we stop the transmission. So
that's really extraordinary.
Yes, yes, it has been, yes.
So I want, for our audience, I know there are some people from Kenya who have tuned in, but I want for our audience from the United States to go back and explain for those of us, for those who may not know that much about the Kenyan Constitution and the history of Kenya, a little bit about, to place the judgments we'll discuss later in context. Kenya obviously had a post-independence constitution in 1963, and then there were a series of reforms before this 2010 constitution. And there were also a lot of political events, and as is frankly common before transformative constitutions, there are often inflection points politically and economically and socially that lead to a new kind of social contract. And I was wondering if you could just sort of briefly give us an overview of some of that, of the previous constitutions, the political violence around 2007, 2008.
Right, yes. I think I'll touch on 3 points in the history leading up to the 2010 constitution. Some may know that Kenya was a British colony. I think it became a British colony in 1920. There was some agitation for independence for quite a while. There was a state of emergency declared between 1952 and I think 1959, and the country became independent in 1963, when we had the Independence Constitution. That constitution did not have provision for social economic rights. It made provision for civil and political rights. But changes in the constitution and in the manner of governance of the country meant that between the 1970s and 1980s, there were periods of political repression, I should say, and violation of human rights. And in the 1990s, there was concerted action for political change. The structural adjustments programs by the World Bank and the IMF had led to a lot of poverty, inequality in the use of resources, a bit of corruption had also brought the economy to a situation where the vast majority of people did not have access to basic human rights. And so the 1990s saw the agitation for this new constitution, a constitutional review process through a constitutional conference involving citizens, civil society organizations took place with a view to getting a new constitution for the country. There was, in 2005, a referendum on a new constitution, which was rejected. Contestation of the election results in 2007 led to very widespread political violence, which led to a number of deaths within the country. And following that political violence, I think there was greater impetus for us to change the way of governance and to agree on the way that we should be governed, which resulted in the 2010 constitution that was passed by a referendum with about 67% of the population approving the passing of that constitution, and it was promulgated in August of 2010. And it has been, let us say, hailed as one of the most, I should say, transformative constitution. It declares so that it wishes to transform the way that Kenya is governed, and that is what it is proclaimed in that new constitution. It contains very many innovations that were different from what we had in the past, but you can speak a little about that, Alicia.
So I just continuing on to that, it is indeed an extraordinarily progressive document. It contains both economic and social rights and civil and political rights, and the right to health very much modeled on General Comment 14 of the UN Committee on Economic, Social, and Cultural Rights. It also changes, it says in the preamble that Kenya will not be a sexist country. It changes the relationship between the federal government and the 47 counties. It does an extraordinary number of things, but the thing we're probably going to concentrate most on is that inclusion of economic and social rights and health rights in particular. And this is something which I'm often puzzled by my health and human rights colleagues who don't actually work at national level, where they just say sort of, well, health needs to be constitutionalized. But that is actually an extraordinarily, excuse me, an extraordinarily complex task. And in the Kenyan case, there were also constitutional implementation commissions on a number of different rights. I was on the oversight body for the Health Commission, which went on for 5 years because it is so very complex to figure out what the judicialization of the right to health might look like in a very complex social context. And there are these structural innovations, the allowing for amicus briefs, the loosening of standing requirements that are in many ways equally important when we're thinking about advancing economic and social rights around the world. And those will come up in two cases that I've selected to talk to you about today, which both have a lot of resonance, I think, in our current times of COVID. The first has to do with intellectual property, and the so-called anti-counterfeit case, which is, of course, an issue now in terms of access to COVID diagnostics and therapeutics and an eventual vaccine. So that case actually was filed before the new Constitution came into effect, which comes up in the judgment. And the issue there was Kenya had an Industrial Property Act, but then there was this anti-counterfeit legislation, and there was some questioning about whether generics, whether that was an appropriate way to deal with access to medications that could be generics, whether for people living with HIV. So I will stop talking and let you explain the case better.
Okay. I think the question of the right to health is something that I think everybody is grappling with, and I think we still haven't found an answer to it. And I think for me, in the anti-counterfeit case, the bigger question was how to prioritize, whether you prioritize the right to health or the intellectual property rights of patent holders. Not that we were saying that those patent holders' rights should be violated, but that we shouldn't have legislation in place that through the implementation and because of the ambiguity in the legislation would lead to the violation of the right to health of a vast number of people who were dependent on generic drugs in the country. This case was filed in 2009. That was before the new constitution with the guarantee of the right to health was enacted. Initially, the petitioners had obtained an injunction to stop the implementation of 3 sections of the Anti-Counterfeit Act, which was Section 2, which contained the definition, 32 and 34, which empowered intellectual property holders and customs officials to stop and detain medicine which was suspected, the way they coined it in the Act, to be counterfeit. What the petitioners did after the enactment of the Constitution is that they amended their petition so that they made a claim under the new Constitution in relation to the right to health, which was then guaranteed by the new Constitution, the right to dignity, and the right to life. And what came out very clearly from their pleadings and from the authorities and conventions that we looked at was the indivisibility of these rights. If you take away the petitioner's right to access the essential medicine, you're taking away their right to health. And of course, if you take away their right to health, you're taking away their right to life. And it follows also, given the nature of the HIV and AIDS, the kind of effect it has on people, you're taking away their right to dignity. So that in determining that case, I think it was important to see the connection, the close interlinkage between human rights and the way that you cannot look at one in isolation from the others. And the petitioners basically were lower income Kenyans who were dependent on generic drugs that were mostly donated. I think the medication was coming in from Médecins Sans Frontières, the doctors' organizations. They had just a few years before, through the Industrial Property Act of 2000, I think 2002, been allowed to import generic drugs. If you then bring in legislation that hobbles the importation of those drugs, then you're creating an environment in which poor people cannot access those drugs and therefore will have their right to life and dignity and health jeopardized. And that was the critical question that the court was confronted with. And it was possible from the pleadings, from the contents of the Constitution and interpretation of the provisions of international covenants that are also part of the Kenyan law, to arrive at a decision that could safeguard the continued importation of those drugs and therefore access to the drugs by the people who needed them, among whom were the petitioners.
So I want to follow up on something you just mentioned, which is that the decision itself does rely on amicus briefs and also cites, for example, a general comment that refers to intellectual property as a social construction. And your opinions often refer to international or comparative law. So one, I think that's probably a little bit unusual for a US trained attorney. And two, things changed, right? With the new constitution, which formerly Kenya had a dualist system, and then it moved to a monist system, which welcomed references to international treaties that became part of Kenyan law. So I was wondering if you could talk a little bit about that.
Yes, okay. Now, under our system of law, we have the system of precedents, stare decisis. I think just like you do have, foreign decisions are persuasive in authority. But under our constitution, I think it's Article 2.5 and 2.6, general principles of international law are part of Kenyan law, and international treaties and covenants which Kenya has ratified are also part of Kenyan law. So that it's possible for us to find, if you like, assistance in determining cases from these international covenants, interpretations, the general comments on the various treaties that Kenya is a party to. A critical part of the decision-making in this area, especially of socioeconomic rights, is the participation of interested parties and amicus briefs. We have rules that were promulgated in 2013 that tell us how to use, to join, to admit parties as interested parties and as amicus briefs. In the anti-counterfeit case, one of the most useful submissions that were made before the court was by the special rapporteur on the right to health. I think at the time it was Anand Grover. And because parties sometimes may not have the information or the competence to bring out all the matters that can assist the court in reaching a just decision that advances the rights that the parties want to advance, the use of amicus briefs, interested parties who may have an interest in a particular case has been really invaluable in the determination of the cases in touching on social economic rights, particularly on the right to health, and I think also in the area of housing and so on. And I think also because many of these cases have a much wider impact than just on the parties who are before you. We may have had 3 petitioners in the anti-counterfeit case, but the number of Kenyans who are dependent on generic drugs were, I don't know, in the region, I think today we may have about 1.5 or 2 million people who are dependent on HIV medication. I think about 69% of them now have access to those drugs. Without proper information being placed before the court, sometimes you may not be able to come up with a proper decision that caters for the interests of all the parties who may be affected by that decision.
I also think if I may, looking at your opinions, and this also goes back to a new constitution, which is quite different from the way judges operate in the United States, that your opinions are opportunities for really public learning about this new social contract and what the constitutional commitments of people within Kenya, of how people are supposed to treat each other and what they owe each other mean. And so often what to a US lawyer might seem unusual, because some of the things that you cite are not strictly binding law. And even the treaties in some respects could be considered non-self-executing, but you use the principles as opportunities for explaining principles in the Kenyan Constitution, which is, I think, absolutely marvelous. And also another aspect that often people who do international human rights kind of forget. It's not just a matter of, oh, okay, now we have a new constitution, but explaining, using the position of the court to explain, to translate what that means into practice in context. And that's how social rights, including health rights, which are so complex, become more concrete, become integrated into people's policies and lived realities. And that's such an important part of the way you write your opinions, in my view. Now I want to move to a second case, which is also undoubtedly an issue that is playing a big role in people's minds, not just in Kenya, but in the United States, where people are getting socked with medical bills, even for COVID medical bills, often when they're pushed off insurance, et cetera, and wages are garnished by some hospital chains. This is a topic that we discussed at an event in March at the Petrie-Flom Center, which I would commend to you. But in Kenya, there is quite an extraordinary case, which we also discussed in March, of women being detained in a maternity hospital for non-payment of fees. And I guess to start off, if you could give a little bit of background on this case, which was from 2012.
Okay, let me go back a little to, let's say, the first 2 decades of independence. I think for a time there, the government was able to give free treatment in public hospitals. I mentioned the structural adjustment programs of the 1980s through the IMF and World Bank in relation to debt repayment. And the government then was required to reduce, in a sense, resources to certain sectors. And some of the ones which were really heavily affected were education and healthcare. When you affect healthcare in hospitals and you ask people to pay for health services, the people most likely to be most adversely affected are women, because women give birth, they require maternity services, they require postnatal and postnatal care, they require reproductive health services. So when you have a health system that isn't catering, that is not providing universal health care, the impact on women is likely to be very, very damaging. Then you have a society where women tend not to be properly educated, not to have access to employment, not to have access to income and property because of cultural and other factors that mean that their economic position is usually very, they're of low economic status most of the time. So in these 2 cases, the 2 women involved were both poor workers living in informal settlements in Nairobi. They needed maternity care. They went to, one was going to go to a clinic in one of the estates in Nairobi, but they thought she might have a breech birth, and so referred her to a government hospital where she might get better care. The other one also had a similar problem, and it sounded like she may require more advanced treatment. So they both ended up in these hospitals. They're not able to pay the money they're supposed to pay for maternity services at the hospitals. And so even though one didn't actually have a problem giving birth, even though she gave birth within 15 minutes of admission to the hospital, she was detained in the hospital for about 24 days because she couldn't raise the amount that she was required to pay for the services she had received at the hospital. One woman had to have a cesarean section, had additional problems, I think like a ruptured bladder and so on. And she had to stay in hospital for about a week or so. And she was also detained because she did not have the money to pay for those services. So the question that you ask is whether you are advancing the right of women to health, to proper reproductive services, to maternal health care, when you detain them in hospital because they're not able to meet the healthcare services. That was the question that was before me. And whether by detaining them, you're not violating their right to health, which is guaranteed to them, their right to dignity. Many of them were forced to sleep. The two and other women are forced to sleep on the floor. Sometimes they don't get adequate food and so on. So the question was whether through the conduct of the staff of this hospital, you were not violating all the rights of these women. And you go back to the Constitution and the things we say in the preamble. There is a famous Article 10 that talks about protection of the vulnerable and the marginalized, which includes poor women. And the question is whether from your conduct as a hospital, as staff employed in this hospital, you're not violating these rights, and whether as a government, whether as a national government or county government, there isn't a failure to meet your obligations under these provisions. And the only really determination one could come to was that given those circumstances, there was a violation of those rights as claimed by the petitioners.
So in this country, we're having debates now, and we have for quite a while, about healthcare being a right. And there are many who say that the United States could not afford healthcare as a right. And the United States is a much wealthier country than Kenya. So how do you think about enforcing entitlements that cost money? I mean, obviously the detention of these poor women in a facility was a violation of rights, but how do you think about access to healthcare as an entitlement of citizenship in a country that has to make resource trade-offs all the time?
I agree that it's difficult to provide healthcare now to everybody. The finances in our country, I don't know about the US, and you say it's difficult, they also cannot immediately afford to do that. And the Constitution recognizes that, and it talks about progressive realization of the rights, of the socioeconomic rights. But it is possible to put conditions in place that help to advance the right to health. For instance, let's leave aside maternal health care, reproductive health rights, and so on for a moment. Let's talk about access for other people with other illnesses. If you take care of the underlying determinants of health, you reduce the burden on people who need healthcare. If you have proper sanitation, you reduce diseases like diarrhea, which affect many children. You reduce diseases like typhoid, which affect many people, and so on. The illnesses that are related to poor sanitation because of inadequate water or inadequate access to sanitation facilities. If you have proper housing for people, you reduce respiratory diseases, because many of those diseases come in because of poor ventilation, crowded places. I don't know, anecdotal evidence seems to suggest that one of the ways that diseases like tuberculosis reduced in Western countries, and you might know this a little better than I do, is that there was better housing, and so there was less crowding, and therefore circulation of air and circulation of the tuberculosis bacillus was reduced. So if you can address the underlying determinants of health, sanitation, good potable water, good nutrition, then you reduce the burden on people from having to seek healthcare because of those illnesses. In relation to things like maternal healthcare, I think it's something that you can plan in advance about. You know that you have a certain population of women who may be of childbearing age at a particular time. You know they will require certain services and so on. So it's something that can be planned in advance. But I note also that we even at the time these women were coming to court, there had already been a policy pronouncement in 2007 that said women do not need to pay for maternal health services, postnatal and antenatal clinics. That pronouncement was again made in 2013, and a circular to that effect circulated to various public institutions. So sometimes it's not so much that we are not capable of doing certain things. It's a way of doing it, and it's a way that information gets to the relevant people. So in 2010, given the circular of 2007, MA and paying fees, they will be catered for by the government through the budgets that go to these public institutions. So it may not be possible to put in place. Are there sufficient doctors in these hospitals? Are there sufficient beds in these hospitals so people don't sleep on the floor? Are there sufficient drugs in these hospitals also? So even if you don't have insurance put in place that makes sure that access to health, there is proper access to health facilities for people.
So I want to take the opportunity, I mentioned before that, and you had said that the policies that were put in place were actually not being implemented effectively. And I want to take the opportunity to read from this opinion, which to me really speaks to the court as kind of a guardian of the fundamental constitutional commitments, a kind of poking the conscience of the nation, because I think it's quite extraordinary language. So in this opinion, which is petition 562 of 2012, you write, "The rights in the Constitution and the international instruments that I have set out above, and which represent the great hope of the poor and marginalized in our society, will remain weak and ineffectual platitudes unless we can unearth from the recesses of our hearts and minds where they are buried under layers of indifference and lack of concern for the welfare of others, even those whom we have a legal duty to serve, the remnants of values, compassion, and empathy that we once had. Without these three, in circumstances such as have been presented before me, all that a court can do is come in after the fact. After great pain and suffering has been inflicted on the minds, bodies, and spirits of our mothers, sisters, daughters, and wives, to offer reliefs that may not quite make up for the humiliations and degradation that we subject others to. And that, in the final analysis, degrade and dehumanize all of us. And then you go on to say that it is not a totally hopeless situation and that new policies can be implemented effectively. But it's really, I think, extraordinary both for the boldness with which you chastise those in power, as well as understand that it's what the courts can actually do to change the underlying conditions is reasonably limited in this kind of situation where there are so many intersecting economic and political policies. Is there any particular way that you see the courts functioning to advance more systemically, a more egalitarian policy-making environment in Kenya?
I think the role of courts in many instances is limited. For instance, in relation to social economic rights, I think one of the provisions is that if, for instance, the state says it doesn't have the resources to do something, then even if you as a court may think you could have done it differently, you don't have the capacity to do that. And there is a clear separation of powers between what the courts can do, what the executive can do, and what the legislature can do. But I think the kind of constitution we have gives the citizen the voice to come to the court and ask for certain things, but it also gives the citizen the right to lobby the government, the executive, the legislature to have some of these things implemented and to use their vote. And I know it's not as an easy thing in Kenya. I don't know whether it's an easy thing really anywhere for citizens to get precisely what is in their contract with their governors. So I think the best that we can do is adjudicate on these matters, pronounce what the people, in our case, the people of Kenya, proclaimed only 10 years ago that they wish to see happen, and maybe it will get done. There have been some changes that have taken place. In one of the decisions that we made relating to detention of people in prison because of default in TB treatment, we asked the government, please put in place a policy that makes sure that people are isolated if they default in treatment in proper facilities, not in prison. And the ministry did that, and I think 2 or 3 years ago, a policy was put in place. I don't know how well it has been implemented, but the fact that there are people in the other arms of government who listen and who take the decisions made by the court seriously and implement those decisions is a critical factor in ensuring that what we put in the Constitution doesn't just become something that is empty. So I may sound sad, sometimes it sounds like it's discouraging, but I don't think it's a totally hopeless situation. I would like to think that we have people in the different sectors of our society who are working hard to ensure that there's access to healthcare for all. I've seen county governments in the last few years who are trying to put in place some form of universal healthcare at a very minimal price for the residents of those areas. And I believe it's something that can be done and that will continue to be done. So we may not have as much clout in terms of moving policy forward, but we can make pronouncements that help to maybe move and point the direction towards what the people of Kenya expect, given that the cases that come before us come because citizens are unhappy with the situation and they want the court to which they vested judicial authority to make a determination on that question.
So I want to slightly pivot now in the conversation because I think you're too modest, but you know, many people see the decisions you've made and the remedies you fashioned as a way to foster dialogue with the other political organs. And I'm wondering now personally, I mean, you know, in this country, there were many women lawyers and law students who had enormous admiration for the late Ruth Bader Ginsburg and patterned their professional aspirations on her. And I think that you have also inspired a generation of young women lawyers as well as other social justice advocates. And I'm wondering if you could talk a little bit about your background and experience and how it led you to become a judge and your approach to judging.
Okay, I think part of the, shall I say, inescapable fact about me is that I am peculiar, quote unquote, in that I was born with albinism. I am a judge with albinism. It is not, it's not an easy situation to be in the African continent where everybody is dark. And so for people who see me, they see, I'm not quite sure how to phrase this, but they see somebody who would not have been expected in the ordinary course of things to maybe have reached the position of a judge. What I would say is that, and I would say this, and I've said this to many young people who are different and who get sometimes discouraged by the situations they find themselves in. It can be because of race. I know that's a big challenge in the US. It can be because of disability. It can be because you're born different in some way. I think what I find is that you have to begin to believe in yourself and your capacity to do things and not be discouraged by what you see around you, what may be said about you. But it also gives you the ability, I think it gives me, let me speak from my perspective, it gives you the ability to empathize with people that you find in various situations. There are many women, like the litigants in this case, who find themselves in situations where either their background, their education, their training, their lack of employment places them in, and you're able to see things and to be able to empathize with them and see where the limitations in our laws, in our cultural practices, make it difficult for them to find a way out. So the fact that I'm different, that I've been able to rise above certain challenges has helped me to be sympathetic and empathetic to the people who come before me as a judge. But my practice also as an advocate in the days before I became a judge, with women's rights organizations or organizations of persons with albinism, with their mothers, and the many challenges that they faced, has made it possible for me to understand that without a properly functioning legal system that protects vulnerable in society, that tries to bring equality between various sectors in various groups in society, between men and women, to advance the rights of persons with disability, we can have a very difficult time trying to create a just society. And that has been principles underlying our constitution, the need to bring a transformation in our society, the need to create a society where even the least among us has access to the basic fundamental rights that the Constitution guarantees to everyone.
So I think that in your judgments, you're remarkably empathetic to, I mean, we in teaching, we often talk about intersectional identities. But for example, in the judgment from 2012 on the detention in Pumwani, you talk about the indifference to poor women, as well as discrimination against women. And in many of your judgments, you're particularly, I think, attuned to how poverty creates barriers to full citizenship and participation in Kenyan society. And is that something that you have always brought with you from your advocacy days, or because it's definitely something that human rights has been criticized about, that we just look at discrimination on the basis of gender or race or sex or etc., or ethnicity, and not in terms of class and economic status. And your opinions are filled with remarks about how poverty poses barriers to fully enjoying rights.
I think if you look at, let's say, the litigants in the 2012 decision, you have single women, so with children, one of whom I think had HIV, so their health status, their marital status, their mothers. We have, in many instances, a failure to educate women. The rights of inheritance for women are still contested in this country. We have the laws that say they should inherit equally with men, but in many instances, they don't. So you will find that women are poor, they are vulnerable because of their gender, as mothers, because of the relationships with their spouses, they cannot, for instance, negotiate matters of sex. So the question of intersectional discrimination really is something that you cannot, that you can fail to note in the course of dealing with a lot of issues in this country. You'll find that at least a few years back, the statistics showed that 70% of people living in informal settlements were single women-headed households. 70% or so were headed by women. So you have poverty, the poverty, discrimination on the basis of gender, discrimination on the basis of sex, and so on. So it's a question that I do not think you can look at one area of discrimination in isolation from the other. And that is what you find in very many of these instances. When you put in disability, then the whole question on all those areas of discrimination is compounded. So as one looks at the cases that come before us, that intersectional discrimination, and that is what came to the fore in the 2012 decision, is that these are women of low economic status, single parents, poor, no education, unemployed. So for various reasons, they are discriminated against, and the policy decisions that are made in relation to access to healthcare, access to education, and so on, just compound the inequalities, the injustices that they face.
Yes, it's very clear how the health system operates in many ways to exacerbate lines of discrimination. Well, we have come to close to the end of the hour, and I don't see, let me see in the chat. There aren't any questions directly for you. So I wanted to give you the opportunity to say anything final, and then I will wrap up.
Okay, I would just say thank you very much for the invitation. It's an honor to speak with the students and the faculty of your center, even though it is on Zoom. I think you're doing some great work in the area of the right to health, and I hope it's something that you will come back and continue collaborating with us in Kenya so that we see how we can advance that right in relation to the rights of women. So I would say thank you very much, and I'm honored to have been part of this discussion. For you, it's morning. For me, it's evening.
Well, it's been a tremendous honor and privilege for us, and I hope there will be an opportunity when we get to invite you in person to Harvard for an event as well as, and I would also love to go back to Kenya. I want to close with another quote from your opinion, which I think is something that all of us in this sweeping pandemic, which is also quite isolating, where those of us who have privilege in many senses are regarding the pain of others, as Susan Sontag would say, you know, we should all be asking ourselves in a way, what has become of our humanity, our compassion? You know, how can we watch in a maternity hospital, a poor woman in labor bleeding, or in COVID to see some of the other suffering that is going on and feel no compulsion, regardless of others' economic status, to act in order to relieve that suffering. And I think that is a good way to end this, because to me, Justice Ngugi, above all, represents somebody who cares, who really deeply feels that the law, for all its frustrations, can be used as an instrument to transform lives and realities. And that is all too rare, I think, in judges these days. So it's really, again, I'm very grateful for you having made this time. And thank you to everyone who tuned in. Thank you.